my topic, which is negligence. Negligence basically is a breach of a duty to take care. There are three elements over here. One is breach, other is duty, and third one is to care. According to the jurists, according to Salmon, Wales, Austin, Clark, there are different shades in which they define negligence. For example, some say that it is a particular state of mind in which there is undue indifference towards one's conduct, one's behavior, one act, one implied word or silence, and what are its consequences. All are the indifferent, undue behavior. That negative reaction or repercussion is called negligence. Whereas they will say that it is the absence of the care which was due to the defendant, that he must utilize his faculties, his mind, his skill, his due care. Whereas Austin say that it is the breach of the omission of a positive duty. There was a duty to do something and you have avoided it. That is called legally omission. You have to make a cautionary measures after digging the road. You didn't take any measure that anybody who is traveling at night might see that there is a big hole which you have for your own purpose, some construction purpose. Clark said that there is a care under circumstances, legal duty, and nothing to do with the state of mind. He said that you must have to focus on the legal obligation. State of mind is a very inner thing, very objective thing. Don't go so depth. Just see whether it was the legal duty of that person or not. That's enough. Then what are the essentials? Legal duty, due care, and the required skill. Then the duty towards the plaintiff, then failure to perform that duty, and the damages which the plaintiff has to bear due to your negligence. Negligence kinds, that is willful recklessness, harm, foreseen, and not willed. Whereas other is simple, without any purpose, without your intention, and not seen. That was not in your prudence that it will be happened, but it happened. Then culpable negligence. Culpable negligence is the purposeful negligence, that is a criminal act. Criminal. That where law imposes some duties and the degree of seriousness was very obvious to you, and there is a consequences that was very clear to you, but you didn't heed to them. Then duty to care, there is a landmark case of 1932, Stevenson. The fact is that one of the customers, when opened up the ginger bottle and he found a dead snail in it, he invoked the code of law. That code of law, after facts finding and after the listening, the lawyer of the defendant, the defendant take the step or the plea that I was unaware that there was a snail and there was a negligence that was not in my mind or in my knowledge. But standard of care we should be reasonable. Being a reasonable man, you have to be thinking reasonably, prudently, and then the absence of culpable negligence. Your very intention should not be intentional to do the harm. That is not culpable. Is you are doing something that is intentionally by your act, by your word, or by your silence or implied silence. Factors. Standard of care adopted, highest care. Human nature, what the human can do, capabilities. Normally a prudent person will think of, or reasonable under the circumstances. Factor determining the standard of care varies from case to case and time to time and events to events. Amount of care necessary, magnitude of the risk you have to think. Magnitude of the care that I am going to do that thing and to what extent it can harm the property or life of the other person. Then magnitude of the risk by the act. What is the amount of benefit derived from it? What is the cost benefit ratio of that? What is the outcome? What you want to derive from it? You have to analysis. Being an educated and a prudent person and a responsible citizen of our state. Then defense is no duty to take care. There is a defense is onus of proof is on the plaintiff. He has to prove that that defendant was done that act negligently. There was not a due care from his side. There was no prudence. He was recklessness in his that act, and he has did that wrong to me in that you can say by injury or